was pleased to hear the contribution from the Honourable Lady for Edinburgh South West. I don't say that to cause her any discomfort, but we find common cause on the issue of polygraph testing. And if I cast my mind back to the contribution during second reading, I do believe that there are distinct differences not only between our criminal justice systems throughout this United Kingdom, but also choices that we as representatives need to make about the appropriateness of embarking upon an untested, an unverifiable system which would ultimately be used to impose further restrictions on somebody's liberty in a way that we can't satisfy ourselves that it is appropriate at all. So I am pleased to find common cause across the chamber from members who do have concern about this creeping integration of the use of an unverified method of assessing offenders. We understand it's restricted to licences. We understand it's restricted now to 3 or 4 discrete areas of offence. But as the Scottish are being cautious, I believe too we in Northern Ireland will be cautious about the introduction of such measures. To that end, I was pleased to hear Les Allenby from the Northern Ireland Human Rights Commission, Chief Commissioner, give evidence to the Bill Committee and highlight concerns that he had from a Northern Ireland perspective. And I recognise the thrust behind the amendments in the name of the Honourable Member for North Down, Amendments 3 and 4. I do, however, just wonder whether these amendments, Mr Deputy Speaker, are necessary, and reflecting on Clause 34 of this bill, saying that it is for the Department of Justice Northern Ireland to decide whether or not the use of polygraphs is necessary. I think that should give enough comfort. The provisions of the bill should give enough comfort about the operational introduction of polygraph testing in Northern Ireland. And I'd make a second point, that I think we should be slow to water down or to remove the fact that counter-terrorism and national security measures are reserved to this Parliament. And I say that not believing that we shouldn't have a role as a devolved institution in Northern Ireland, but that we should be cautious in seeking to attain power on national security and counter-terrorism grounds, recognising the divergent views that we have in our Northern Ireland Executive and some of the competing arguments that would be made, and ultimately the less protection we may get should cross-community consensus be required for the introduction of those powers. So I would not be minded to support amendments 3 or 4. Mr Deputy Speaker, a recurring theme throughout the process of this counter-terrorism bill has been the retrospective application of it. And the Minister will recall that I was concerned Northern Ireland wasn't included in the retrospective application of the extension of serious terrorist offences, and was pleased whenever Northern Ireland was included, and that the implications, perceived or otherwise, of Article 7 application on the retrospective nature of these offences was overcome. And I say that, Mr Deputy Speaker, because when we take decisions like this, when we decide as a Parliament that we are going to extend the custodial period of someone's sentence, we need to do it with our eyes wide open. So that's not to ignore that there could be an argument raised that Article 7 is engaged. But we have to thoughtfully reflect, one, what's a policy imperative for doing so? And two, if there is a challenge, can it be robustly defended? And I think through the consideration that there has been on the floor of the House and the Public Bill Committee and elsewhere, there are strong, compelling legal arguments which differentiate between a penalty and the enforcement of the penalty. And I think it is appropriate that we as parliamentarians say very clearly on the record that we are not changing the penalty for anyone who is currently in prison and subject to a terrorist offence and sentence. Their sentence remains the same. How that sentence is operated and how it is enforced is different, and in making that distinction, clearly say that Utley, as one legal authority, the UK and Utley, Hogben and the UK, Kafkaris and Cyprus, Grava and Italy all indicate the distinction between the extension of a penalty and the enforcement of that penalty. And I think we should take some comfort in saying that whilst there are particular issues in Northern Ireland that we should be alive to, As I say, approach these issues with our eyes wide open and recognise that there will be some that will seek to manipulate them for propaganda purposes and so on. Nor should we be prepared, or fail to be prepared, to stand up robustly for the rule of law within our country, to stand up robustly and say, no, you may not like it, you may not like the rational choice that we as Democrats make within our legal system, but we will not cow to the threat of violence or agitation or propaganda, which seeks to subvert the very norms and principles of democracy that we all enjoy. And so on that basis, I couldn't support amendments that seek to remove the retrospective application of this bill. And I do want to welcome, just in closing, Mr. Deputy Speaker, because there was a suggestion of a notional time limit, and you've been gracious enough to sit calmly as I move towards a conclusion. I do think there is some sensible merit in New Clause 7. I do think New Clause 7 has been approached and drafted by Her Majesty's opposition rationally, recognising that there are issues within Northern Ireland, that it would be important over a period of time, be it 1 year, 2 years, 3 years, to carry out an impact assessment as to how this bill has operated within Northern Ireland, whether it has made a significant positive or detrimental impact, and to lay a report before us in this House in conjunction with the Northern Ireland Executive. And in recognising that I think it is a sensible and well-drafted and appropriate amendment tabled by Her Majesty's opposition, I hope, even if it's not moved, that the government recognise that in taking decisions such as this, and with eyes wide open recognising that there could be concerns around the operational impact and the opportunity for people to manipulate the democratic and legitimate choices we take, that the government will take these things under review and will consider if the consequences were warranted, merited, and these choices were appropriate to adopt today.